Welcome, everybody. It's nice to have everyone here that's involved in structuring an EB-5 direct investment. My guests include Rupi Chima with EB-5 Diligence, Phil Cohen with Strategic Element, Michael Holmeyer, Holmeyer Law, and Michael Harris with Harris Law. All the people on this call, on this presentation today, are EB-5 experts. And so what we intend to do is explain to companies how and whether EB-5 capital is reasonable for you to consider as part of your capital stack. So when we look at raising EB-5 capital, I believe it should begin with a call to me and to Rupi Chima. Rupi, when you do the initial interview, initial consultation, can you give us a quick overview of what does that call typically sound like, and what kind of information are you trying to elicit?
So it's basically evaluating the likelihood of this business being successful. And of course, for EB-5, we want to make sure that the job creation is likely. So that's how the call usually starts.
And how likely do you want to see the job creation?
Oh, it should be imminent. I mean, that's the most important aspect, one of the most important aspects of an EB-5 offering.
So I think that's an important thing for you as issuers to recognize, is if you're looking to raise EB-5 capital, the starting point is job creation. If there isn't a high degree of certainty, not that, we'd like to create jobs, or we intend to create jobs, but I mean certainty that you're going to be creating jobs. And I'll tell you, if you're a manufacturer and you've bought the building and you've outfitted the building, well, you're probably going to create the jobs. If you are a tech company and you have just raised a sufficient amount of money to grow your company and you have plans to hire 35 people, I think that's also a reasonable starting point to consider EB-5. So we are looking for businesses, essentially, when we evaluate a company, for the likelihood of job creation and the capital stack being in place. Now, you may say to yourself, well, if the capital stack is in place, if I've got all the money I need, why would I want to go into EB-5? And the reason is because the capital is a lot less expensive. You can give up less equity for the same amount of investment dollars, and you're not dealing with some of the more onerous negotiating terms that you might have with other investors. So that's why EB-5 can be very helpful. But unfortunately, you can't count on it. If you work with me and I work with Rupi, and if we can diagnose that your deal checks off all the boxes, and that we think it's going to be something that we can sell, and we can sell relatively quickly, well, certainly that is a positive, but investors don't want to rely on the fact that you are going to raise money from EB-5. They want to know that you have access to other sources of capital. Rupi, any other thoughts about the preliminary call that you have with potential issuers?
No, I would say that's the most important element, really. If it's something that's very early stage and they would be completely reliant on EB-5 financing, we would probably tell them that it's not a suitable offering, for our marketplace.
Right. And it is unfortunate because this program seems to be designed for job creation. But the truth of the matter is, in the environment we're at now, investors, immigrants, the ramifications of not satisfying the job creation and other elements of USCIS requirements means that they could be asked to pick up and leave the country. And that is such a burden that we will try to avoid that at all costs. And they will only select an investment that they have a high degree of confidence that that's not going to happen. And they're willing to give up a lot of upside potential on an investment if they know that the immigration aspects of a deal are highly likely. So once Rupi has done her preliminary review and I've done my preliminary review, a couple of things I'm going to try to elicit are, what are the offering terms that the company is looking to give to investors? And I'll also discuss the selling agreement of our firm, our broker dealer, and what we would cost for them to raise money. After Rupi has given her initial blessing, Phil Cohen, a business plan writer, would be the next person that you should be talking to. Phil, can you walk us through how do you get started with somebody? What do you ask for, and how long does it take? And we'll start there.
Sure, Kurt. Yeah, so I think it's important, maybe I'll just kick it off with a preliminary comment that fundraisers should be aware that in each stage, there's always a bit of drilling down, there's always a bit of sort of testing your concept, testing what you're doing against the various components at play. And that includes the USCIS rules, that includes the laws, that includes the investor perspective. So when I get involved, I do also a preliminary review, and because I'm often the first person or team member to see things in a minutia, at their minutia and at their finer details, I feel that part of my job is to red flag issues and to try my best to identify issues that the other professionals on this webinar might be interested in knowing or might wish to comment on. So I call it, preliminary review, sniff test. So I try to consider things from the immigration lawyer perspective, the securities lawyer perspective, the marketing team perspective. And at the same time, I am none of those. But I consider it my job to be aware of some of the concerns that have come up based on my experience and to flag those things for discussion, to get those other professionals involved as soon as possible. So my guiding principles include what USCIS calls credibility or legitimacy, and then of course the approval process, and of course what I know of what investors look for. And again, I'm not the expert in any of those fields, but so the same way Rupi asks certain questions, I might ask the same questions again, but every preliminary discussion is a bit different for me, because depending on the answers I'm given, it leads to other questions, and I try to dig as deeply as I can without engaging for too long, because we all want to get formally engaged at some point.
So Phil, when you're looking at the legitimacy of an offering, or you're approaching it, why do you think USCIS is looking for legitimacy? What's their purpose of that? Well,
beyond the fact that it's just a stated requirement, they very specifically say that they want the business plans to be credible. So what's behind that? Well, in part, it's they don't want to see that investors get cheated, and in part, they don't want to see that the program rules are being circumvented, or that people are playing games to try to make it look like one thing when it's really another. And
especially with job creation.
Sorry.
Right. Phil, what are some of the things that you ask for? Like, by the way, do you get started before you have a retainer agreement in place?
No, I do the preliminary review, and I'll flag certain issues, but in part that for me is to scope the work and scope what needs to be done. Some cases are more complicated than others. So I'm trying to do two things at once, to see how much work it's going to be for me and see what issues require comment or consideration or might just be non-starters.
Great. And some of the documents that you'll ask for in order to get started in your preliminary review include what?
Well, it depends on the company. Some companies have no documents at all. Some companies have a business plan or a pitch deck. Typically a pitch deck's a great starting point, because I don't have to get too deeply into reading hundreds of pages of documentation, but it's enough to see the high level view of things and to prompt me to ask certain questions at certain points. Financials are also helpful too, financial projections.
Great. Phil, before we move on, costs, what does it typically cost someone to retain your services?
My base rate's $6,500 for writing a business plan, and that is assessed according to the preliminary review that I do. Sometimes it costs more. Sometimes there's the multi-pronged business, multi-location, that sort of thing. But that's the base rate.
Great. And how much of that cost is affected by the documents that they have available?
Some of it, the things that I find most commonly that people need help with are financial projections and market research. And I can help with both of those things. But the market research, sometimes if it's a disintermediating product, for example, might be very hard to come by. The financial projections I can help with, and so that would affect the price. And if we need to buy market research or do a feasibility study, obviously that costs extra.
Great. One last question, Phil. When we talk about marketing research, that is a requirement of USCIS. Why do you think USCIS requires that a market research be provided?
I think it comes back to the issue of legitimacy primarily. So it's about proving what you're saying. And so market research is a much higher level view. What is happening in the marketplace? What are the competitive forces? Who are the big players and so on? That's the higher level. And that, if you see that in the market research shows that this is a business that's dying or an industry that's dying, well, there might be an issue at hand there. And then the next level could be a feasibility study, which is much more business specific market research.
Terrific. So we've gone through Rupi. She's done a preliminary review. We've gone to Phil. He's asked for the documents. He's working on a business plan. The next stop is Michael Homeyer. Michael, at what point in Phil's work do you feel comfortable getting started?
Usually when Phil, the business plan writer, has drafted a document or a couple of documents that are mature, that is, they're, say, 80% complete. They don't have to be absolutely final, but they have to have most of this information that he has derived from the client through a question and answer back and forth process, so that I have a lot of substance that I can take from the work that he's done and import that into the securities disclosure documents.
And by the way, if I could just interrupt, I apologize, but I didn't introduce you as a securities attorney. So Michael Homeyer's job is to put the offering documents together, which we're going to be using to raise capital. Sorry, Michael, if you don't mind trying to pick that up.
But just as in the currently suspended regional center, the indirect program, direct EB-5 almost always, not always, but almost always involves investors making what is considered by the securities laws to be a passive investment, in which they are not going to be primarily responsible for the future of the money that they sink into a business opportunity. And in those cases, the SEC says those investors are entitled to the protections of the securities laws, which require at their heart full disclosure of all material facts about the business. Happily, Phil Cohen, the business plan writer, is generating a lot of that information that he's getting from the same client, the business principals, and he's putting that information into the business plan. Therefore, I don't need to get it directly from the client through that same Q&A process at rates. We all know attorneys are the most expensive folks on the team because their rates are as high as they are. And so the more work that can be done by the client, the more work that can be done by providers like Rupi and yourself and Phil in generating the information that I then take and put into my documents, means my work is only a kind of a writing and making sure that there's a development of full disclosure and that the developments are clear and consistent throughout the documents that I write, as opposed to actually generating the information themselves. Phil's done that, Rupi's done that, you've done that. So obviously it takes me less time, and my cost at those high expensive rates are a lot less than they otherwise would be. So the bottom line answer, on a direct project, I'm writing a PPM, I'm writing a subscription agreement, I'm writing or converting a company agreement or a limited partnership agreement. I use as much information as I can get from those professionals who have contributed before me.
Great. Well, you've brought up some great points. The most important, obviously, is why are Rupi, Phil, and I charging so little?
Because you have to.
So, Michael, obviously, putting the offering documents is a significant portion of what you do. And we'll talk a little bit about the types of offering documents and the structures you might use based on the size of the offering in a moment. But do you also get involved in the corporate issues as far as structuring companies? Is that part of your role in this? I
do, because I am not just a securities attorney, I'm also a corporate and transactional lawyer. So not only am I able to set up the entities that are used in the deal or that are tangential to the structure of the transaction, but I also can write the contracts between the various parties that actually make the deal work. So I actually wear 3 hats as an attorney instead of just one. Yes, it's the securities work, but also I can assist if it's not otherwise done in the corporate work as well as the transactional.
And as part of that effort to protect the assets of the issuer?
Yes, absolutely. Now, with a group of people like are on this call right now, you all have experience and you know that issues such as where assets are located is a very important issue for a business owner. The assets may be in the company in which the investors are investing into, or they already may be situated in affiliated entities, depending upon whatever was appropriate for the business owner at the time that the business was launched, and may no longer quite be as appropriate now when you're thinking of bringing investors in who want to know that they're actually investing into something that is in fact a business and not just some shell. Or and so, for example, having those assets in affiliated entities is something that I assist companies in accomplishing if they haven't already crossed that bridge. But they may well have done that with Rupi, with you, with Phil, and the discussions that they're engaging in and getting that information together, only coming to realize, gee, I really need to reorder the chairs here in order to make this work effectively, because I am bringing in an entire class of investor, whether it's 1 or 2 or 3 or more investors. It's a new class of investors that is distinct and has these EB-5 program requirements, but also has non-EB-5 financial investor requirements that need to be complied with. Sometimes that causes the business owners to understand they need to reorder things, make some changes in order not only for protection purposes, but also to make the deal attractive to the investors.
Right. And because EB-5 is dealing with, let's just say, less sophisticated investors, and I don't mean that as a knock to the investors, but as a class, they're not coming in with a lot of leverage. Obviously, you can structure things in a way that can be very helpful to the issuer. Michael, I want to go on to one more point before we move on, and that is there's a difference between the cost and effectiveness of a private placement memorandum, or as we abbreviate it, PPM, versus, let's say, a long form operating agreement. When would you use an operating agreement for a capital raise, and when would you?
Subscription agreement, Kurt?
Oh, I'm sorry, subscription agreement. When would you use a subscription agreement, and when would you opt or recommend them opting for a private placement memorandum?
That's a terrific question. The securities law requirements don't change according to the size, for example, of an offering, whether it's a single investor or 100 investors. The obligation of the business before it takes the investor's money is to give that investor access to full information about all the material facts of what it is they're getting into before they make the investment decision, so that it can be the most informed decision they're capable of making. So again, that information can be conveyed in one of 2 ways. It can either be conveyed to the investor by giving the investor an active role in the management of the business, so that the investor can protect himself or herself by taking that access and using it and reviewing the books and records and accounts of the company and continuing to do so on an ongoing basis, which, by the way, is a very time-consuming process and a burden to impose on an investor who may have another business of his or her own that they're conducting, or they have other life issues that they're involved in, and they may not be able to exercise oversight rights as would someone who intends to be fully active in the business. If the person's not fully active in the business, they can't protect themselves by that access. Instead, they protect themselves by paper. And that is provided by the disclosure documents, the PPM, the subscription agreement, the operating agreement of the company. Remember, those latter 2, unlike the first, are agreements. They are contracts. They are a set of promises between the investor and the business owner. The PPM is just a summary of disclosures. It's a summary of what are the primary points of the company agreement, what are the primary points of the subscription agreement, and what are some additional items of information, actually a lot of information. But the PPM is not a contract. And while there is fraud liability that attaches to false statements in a PPM or misstatements or omissions from a PPM, they are not the operative documents, but you need to make sure as an investor that the disclosures in the PPM that says, this is what the subscription agreement says, and this is what the operating agreement says, are in fact what those agreements actually say, which is why in best practices, both of those agreements are given to the investor along with the disclosure document. But I would say the bottom line answer remains, if the investor is not going to be active in the management of the business, he's going to be passive, and this is an investment where he's not going to be involved, the only way he can be adequately protected and informed enough to make the kind of investment decision that the securities laws require that he be enabled to make is through being given the paper and the opportunity to review that and have his questions asked and answered.
Okay. So, and Michael, in our previous conversation, you had helped me draw a line, and that line that we came up with was 4 to 5 investors. So once you get beyond 4 or 5 investors, I believe it's your opinion that the issuer is best served and protected through a PPM. And if they are less than 4 or 5 investors, then it may make sense for investors to participate in a subscription agreement, assuming that they're going to be more active in oversight.
That's correct. But I will tell you that oftentimes securities violations are judged after the fact, where it's too late to change things on the ground. Things have happened, and what happened has happened, and that cannot be changed. So if an investor is brought in without a PPM and they are supposed to have an active role in management of the business, if they choose not to exercise that role, that may be their choice, and that's up on them. However, if everybody really knew that these investors were not going to be active and they never did conduct an active role in the operation of the business, even a minority active role, but still active, then I would suspect that the government would take the position this was not a real situation of active participation. So remember, 4 or 5 investors suggest if you start getting above that number that the investors are probably passive and not active. It's hard to have 10, 20 cooks in the kitchen at the same time.
So this is fascinating to me. So we've got accredited investors almost exclusively. In fact, if you work through us, exclusively.
Yes.
And in a small deal where they're just looking to raise, let's say 3 investors, and at this moment it's $500,000 per investment, so $1.5 million. Would the issuer be under any kind of responsibility to provide these investors who may not speak English, right? They may not be sophisticated in any way, although they are accredited because of their financial condition. Would you think that an issuer could unexpectedly put himself into a vulnerable position because there was no way to assume that these investors could actually look after their own interests?
Yes, absolutely. That's exactly what I'm saying. And remember, we're talking about the level of activity that the investor is allowed to have and whether he does or doesn't actually carry that out. Yes, if he's not given any voice in management, then he, of course, can't be active in its management. On the other hand, he may be given active rights and full opportunity, and he chooses not to exercise it. So those are the two extremes. But in the middle is where someone who, and just because someone is a passive investor doesn't mean that they are not sophisticated. It just means that they're busy, perhaps,
right,
and they don't have the opportunity to be active that perhaps they thought they might at the time they made the initial investment. The company's obligation is not cast in concrete. These are mushy, kind of unclear lines that are being drawn that we're saying maybe it's around 4 or 5. There is no rule that says up to 4, you don't have to do a PPM, and 5 or more that you do.
No, I understand. Yeah.
It is not that clear. But remember, it becomes an argument later when you have a history, and if people in that history are demonstrated as not having had the opportunity to participate, the question is then going to be asked, what was the substance of why they didn't? Was it because they weren't allowed to, or because they chose not to?
Right.
Yeah.
You always need to look through the lens of this deal failed, because no one's going to complain unless it fails. So let's just take that assumption, and what do you want to be in court with?
So the safer thing for the business to do is to buy itself some insurance by having a disclosure document on paper that provides full information, even if the investors are intended to be active, just in case they turn out not to be, or
Right.
God
Now,
forbid
Michael,
something should happen to them health-wise, for example.
I would assume that you don't get it started until you've also got an engagement letter in place or engagement
That's true.
agreement in place.
That's true.
Give me a sense of what it costs to put together all the documents necessary for an offering with a PPM versus all of the documents that are involved if the client chose not to use the PPM.
I think if a client chose not to use a PPM, the cost of those documents is probably half of what a reasonable budget would be for actual documents. That budget, done by a professional like me as a solo practitioner, not in a large law firm, is probably a reasonable budget is going to run between $20,000 and $45,000 for those documents, which is why, again, it's incumbent upon the client, the business owner, to have expert professionals like yourself, Rupi, and Phil do as much of the work as possible so that I don't have to do it at my rates, which would then put the cost of the budget at the low end of that range as opposed to the higher end, where I either am doing more work.
What if the client came to you and he was already raising money or had just completed raising money? So let's say they had gone through a Reg A offering or another Reg D offering. Would those documents help reduce your costs? Or, as you said earlier, it's hard to rely on them completely and you still need to do your background work. So how much of a cost effectiveness is it to have those documents?
It depends if the documents are good or not. A Reg A, which has already received SEC approval, in effect, those documents are going to be pretty good and they're going to provide information that is pretty clear, or the SEC wouldn't have stopped asking questions about them because all their questions had been satisfied. So I would have a lot of confidence, assuming the deal wasn't any different. However, small changes can make significant impact down the road on whether or not something was addressed in prior documents or not. And if it was not already blessed by the SEC, but it was addressed, it may not have been addressed adequately. And again, I try to give the client the benefit of cost savings on work that's already been done and not reinvent the wheel. But it's my professional obligation and my ethical obligation to the client to confess to them if I believe that, based on my 11 years of experience in EB-5 and my 37 years as a securities lawyer, if I think the prior disclosures are inadequate, need to be beefed up, or need to be changed to meet changed circumstances, I'm going to tell the client that. And say, to be adequate, you've got to cover what's missing.
Right. And we've experienced many times where people brought in their documents from a previous attorney and thought that it was just a quick rewrite, and it actually became even more cumbersome trying to or rewrite things.
Yes.
Okay, so Rupi, Michael has now gotten Phil's documents and he has drafted the offering documents. Let's assume it's a PPM, subscription agreement, operating agreement. He may have worked up a new company in order to help protect the assets of the entity. That comes back to you. What do you do at this point? What's your next step?
Well, typically, Michael or Phil, would kind of keep me in the loop. Then I would probably have drafts of what they're working on. So let's say, Michael gives me a draft and I have a draft from Phil. We try to do our due diligence in parallel as much as we can. So, we're not adding weeks of due diligence at the end, before the offering can go live on Marketplace, because the requirement, Dalmor has, the broker-dealer has a due diligence requirement, and the whole due diligence file must be approved by them before the offering actually can be sold to investors. So we try to do as much work as possible during this whole drafting phase. So, we're going through that right now. And what I found is, we've been really involved in the drafting phase. So some of the issues, for example, what was discussed as what was being let's say the preferred return that was being offered, that was discussed initially, and then some things changed. So then we look at in conjunction with talking to you, hey Kurt, what's marketable? So things like that. Then you go back to the securities attorney and maybe make some adjustments, maybe 526 denial language. So we look at it from a marketing perspective as well and make recommendations. So those changes might get incorporated by the securities attorney. And for example, right now we're looking at an entity that has a long operating history and there's a lot of affiliated entities involved. So we're doing a lot of digging. We're making sure all the contracts that they mention in the PPM are actually in place and executed. And we are looking into where the assets are actually held. For example, the real property is held in one entity, and the the entity that the investors are investing in is an operating entity. So we just want to make sure that things that are being said in the PPM are actually true, and that they are backed up by actual documents that exist. So we may come across something that we think the PPM it warrants a different disclosure, or something that the securities attorney might not be aware of. So we can really assist in the drafting stage. Our due diligence can really assist actually the securities attorney in making sure that those disclosures that we're reading are actually accurate based on what we have uncovered.
In order to do that, do you need to wait for the offering documents to be complete, or?
It helps to have a draft for us to know what disclosures are being made. But our job is to really verify the facts based on what the issuer is telling us, based on their financial projections, based on their business plan, if there's contracts out there. So we are actually, just trying to vet as much as possible and during the drafting stage.
Right. I think we all have an interest in these EB-5 offerings to be successful, raise the money that they're looking for, find the investors. But I also believe that it's fair to categorize, Rupi, your role as looking after the investors' interests, making sure that you have checked everything that has been made, that a claim has been made about in the offering. And I look at Michael Holmeyer's role really as looking after the issuer's best interests and protecting them and structuring a deal that meets their business needs. Do you think, Rupi, that's a fair statement?
Yes, I would say so. And obviously, our role also is to protect the interest of the broker dealer, right? I mean, they have a certain due diligence requirement. They want to make sure they avoid any potential liability. So they want to make sure that everything is being disclosed and all the documents are there that need to be there.
Right. And as a representative of Dalmore Group, a broker dealer, I cannot put an offering in front of people until your due diligence has gone through our compliance department. And so, this is just another layer of review and hopeful protection for investors. Now you're done with your due diligence review. And so we've incorporated Phil's work into the offering. Michael has drafted the offering documents. You reviewed them. They've gone back and forth once or twice, and adjustments have been made. And now,
or at least 5 or 7 times.
5 or 7 times, at least. And now your report gets sent over to Michael Harris along with the offering documents. Michael, I've alluded to your role as kind of the coach. You have to make sure that from your perspective, investors, who are really petitioners, are going to get what they expect to get. Can you tell us how you go about that role?
Sure. So as an immigration lawyer, I have a unique role here where I'm actually operating in a multidisciplinary focus, where I'm looking at the interests of the developer, but at the same time also as to the benefit that the investor is going to be seeking. It is, after all, a benefit program for them that they're going to be requesting a green card through. So I have to review everything that's been provided to me and make sure that some of the fundamentals are there that will pass the scrutiny of the immigration agency, USCIS, and their program office for EB-5. So I have to take a view towards things as an adjudicator would, to make sure that the investor really will be successful with this job creation program that they've set out to do from this project. So I end up having to be the last in the process here, but I have to go through everything that's been provided to me with an eye towards that investor's success.
Right. So obviously, Michael Harris, if everyone else has done their job properly, your job should be relatively confirming things, but things don't always go properly, and not everyone does their job as well as we would like. Could you ask to talk a little bit about jobs and verifying jobs? So one of the things is that the group that we've talked to so far is talking about projecting. But how does an investor get comfort that the jobs that have been stated to will be created? How do we verify that? How do you see that as the best practice?
Well, first, of course, we go to the roadmap of how those jobs were forecasted to be created in the business plan, which is what is required to demonstrate how those jobs will be created, fundamentally based on the assumptions in there of the business. After that, at the end of the line or near the end of the line of the process for the EB-5 investor, we need to verify in these direct projects that the actual jobs for full-time workers, for either U.S. citizens, permanent residents, or others that are authorized to work, have been gainfully employed in a full-time basis for the issuer, if you would here, or the job creating entity that is involved with the project here. We would have to do accounting there to make sure that we have all of the required HR records, as well as payroll records and annual tax records from the employer. There might be some other creative options that the employers might be able to utilize to make that easier for them at the end of the day too.
Right. Do you find that, do you try to set that expectation with issuers up front as to what they'll need to provide on an ongoing basis to protect the investors?
Definitely. They really need to take an eye towards that from the very beginning, and ideally provide a monthly or quarterly report regarding how they are performing in the business. I think that is a very helpful thing to be done, probably on the broker dealer or security side, which I can't really speak to that compliance requirement as much. But for the immigration agency in the process there for the investor, their life is going to be a lot easier if they start to collect the required documentation from day one, and rather than having to deal with it at the end. Again, there's also some government programs such as E-Verify that might even make this easier for some employers to keep a record of having lawful employees working for them. There's some creative options there, but it's
Mike,
important.
tell us a little more about E-Verify.
So E-Verify is a optional program for employers to use unless they're engaged in a federal contract with the United States government, that allows them to have each worker verified through the Social Security and work employment system with USCIS to make sure that they're authorized to work. Their information, the information of the employee, is entered into a database that then provides a hit, if you will, of whether or not that employee is actually able to work. And that provides a record trail that allows the issuer to show that they've had a qualified U.S. worker working in that EB-5 position. And it can make their life easier potentially if they're able to go through the E-Verify process to document that at the end of the day when we have to show at least 10 new jobs per investor.
Right. Okay. So, Ruby, I didn't ask you about the costs. What do you typically charge for due diligence on a project?
Well, it's typically for the issuer, the role that we get involved in on the drafting stage and providing the due diligence to marketplace, we charge $10,000.
Great. And Michael, can you tell us a little bit about what you charge for your role in this process?
Sure. So there's really no one size always fits all, but we have a range on the developer side, that typically ranges, I would say, anywhere either as an hourly engagement with maybe a $10,000 retainer to upwards of more than $20,000, if not more, for some projects, really depending on the size of the project and the scope of the work that's entailed. It really can differ in some of those instances. It can vary, and of course, we might have the ability also to work with the investors of the project to as well, to be able to help them guide them through some of this process. So those costs I don't really necessarily go into, but it really also depends there on the sources of funds of the investor, which might be of some interest to the issuer to be comfortable that the sources of funds won't get rejected by their bank, for example, from that investor.
Great. So let me just go through this, guys. I estimate that based on the numbers that you've given me, 10 that Rupi mentioned, 6 to 10 for Phil, 20 to 40 for Mike Holmeyer, 10 to 20 for Michael Harris. It puts us somewhere around, on the high end, 80 and the low end, 46. So depending on how much you've prepared yourself as far as offering documents or business plan, how many investors you're looking to raise money from, I think you should probably estimate somewhere between 50 and 75,000 would be, I think, a reasonable ballpark. So you've got the costs of that upfront. You've got some time expenditures. You're going to have some upfront costs in getting all this information over to Phil, and you're going to be working with Michael Holmeyer. You're going to be working with Rupi Chima, and then ultimately Michael Harris will be working with you to make sure that things are organized. And Michael Harris will also put together a I-526 template package. Now that will be given to every investor's attorney, so that, Michael, you want to talk about that?
Yeah, that's one thing I wanted to mention, because there is some explanation needed regarding, right now there is no required pre-approval process that we have to go through with the immigration agency. Despite that, you need a qualified team of professionals like Michael Holmeyer, Phil Cohen, Rupi Chima, and you, Kurt, that are able to structure this according to the latest guidance, policy, regulations, and law from the EB-5 program, to ensure that that complies with the government's rules, so that you don't get rejected or denied at the investor level later on. So that's where I come in, is understanding all of that. I have to put together a model, a package filing, essentially, or a template that each investor is essentially going to use. It will be a template of materials of really the ability that allows the investor's lawyer to keep on point with the story or narrative about the project, to ensure that nothing is told differently from one investor to the other. You don't want to go to a project where they don't have a template ready and they then ask for your lawyer to create it for you. A lawyer that represents multiple, maybe, not the same investor on different parts of the deal there. So I think it's important that you have a template that the immigration lawyer is preparing that is used by all of the investors in the same format.
I do too, Michael. Do you see a benefit to including Rupi's due diligence report in your 526 package? Would that be helpful to an adjudicator in your mind?
Oh, I definitely do think so. I think it can serve as the basis for the investor memorandums that we have to write to explain everything. I know that Rupi's reports are probably more voluminous than some of our memorandums have been, and really kind of mirror some of that in a way as well, by giving us analysis, charts, data that we're able to utilize regarding various aspects of the project, from job creation to corporate history to targeted employment areas, or what the capital stack looks like, or if there's real estate involved, or commercial leases that have been involved there. So all of that really can serve as a benefit to us and maybe to others in the deal making process here.
Great. So we've talked about costs. We've talked about all of this effort. Let's talk about why you should bother doing this. I'm going to use a couple of assumptions. Imagine for a moment we have 6 investors, and those 6 investors are going to each invest $500,000. So you're going to raise $3 million. If we take the midpoint on these costs, we're about $60,000. I rounded it so it would be even. That represents 2% of the $3 million. So if you're an issuer, not too big, but you're going to create in the neighborhood of, now we said 6 investors, that's 60 jobs. If we have a 30% job cushion, which I would like to see typically, that means you're probably going to need to create 80 jobs. And that's a big number for some businesses, but but for some businesses, it's actually quite small, like a manufacturer that I talked to this morning who is going to be doing 260 jobs. So obviously the type of business you're in is going to have a big impact on whether these economics are going to make sense for you. As far as additional costs, when it comes to selling the deal, the broker is going to get compensated partly from an administration fee, which issuers will charge to the investors. And also typically there is either a back-end fee or a warrant position that a broker dealer would take on a project. The benefits to all this is that it's an opportunity to raise money from people that are desiring immigration benefits. So you get big chunks of money without a lot of negotiating. In fact, typically no negotiations. It's an avenue that will work for some. So I think that that's generally the overview of how to structure an EB-5 direct investment. Is there anybody who has something they want to add before we call it a day?
I would add one thing, if I may.
Yeah, great.
It's been sort of talked around throughout this webinar and implied, but perhaps it should just be said outright too, that someone raising money through the program should bear in mind that, yes, we are all professionals. USCIS presented here as a team, and sometimes we're more cohesively involved than others. And it's incumbent upon the issuer to bear in mind that they have a certain responsibility in terms of ensuring that we're all in the loop, communications wise. It's easier for me because I'm usually up front and at the beginning, but it's not always my right or my position to share the information with the lawyers because I have not been advised that it's okay to do so. So I treat it confidentially unless I'm told to send it. So keeping everybody in the loop throughout the process. I mean, Rupia referred to this as well, is that throughout the process, things come up and it changes the deal. It changes how everybody here might see things and may wish to comment on it or may have something to say that will affect the rest of the group.
That's a terrific point. We're all working on a deal together as we speak, right? This is a big deal that was potentially going to raise, I believe we're talking about $20 million. And we have just come to the realization that we're going to have a weekly call with all of us participating. And I think, Phil, that's exactly what you're referring to. And that is, we really need to know what each of us are doing, because otherwise we're going to waste our time and we're going to waste the client's money.
Hey, Kurt, if I may, just to chime in on the observation that you offered with one of my own. You made the point that these deals from an investor's perspective aren't negotiable in the sense that they usually are given the investment opportunity on a take it or leave it basis without really the opportunity to change things. However, I would point out that especially currently in the direct EB-5 space, it's a highly competitive environment where there are a number of very interesting, and I would have to say, qualifying projects that are worthy of an investor's attention. And that if the investor doesn't like what he sees, and it's not a good deal, and it's not documented in the way that really makes an investor feel comfortable that he or she is getting all the information they need to make a good decision, they can and will look elsewhere for an alternative. And even while they may not be able to renegotiate the terms of that alternative either, if it is one that they find looks better or just looks more straightforward, they may opt for that. So there is still some obligation imposed on business owners. They need to put together the best documents they can and offer a really solid, fair deal to investors if they want to compete for the investor's attention.
Right. And I would add to that when you're talking about a company that's really only going to add, let's say 15 or 25 jobs, and so they're looking for one investor or possibly two investors, you do have more opportunity to negotiate. So you can change the documents. Once you get a number of people in, they all have to be treated the same way. It gets much more complicated. So I do see my role in many ways of working to structure a deal that will be acceptable to the market And so if you look at a deal and it doesn't have the protections in place, and maybe in some ways, you know, a denial is possible at the Immigration Service, and you want to make sure that you understand what the implications are. Are you going to get your money back? Is there money being set aside to pay you back, or is it promise? So thanks, Michael. Thanks for that concluding statement. Guys, I think we did a good job of covering what issuers need to know to consider EB-5. Thanks you so much for your time today.